Okay, here in the national
Yes, Mr. Green. Good morning, my lords. My lords, the way I intend to approach my submissions is as follows. First, I'd like to deal with why the respondents are right as a matter of, the respondent is right as a matter of principle in this case. Secondly, I'd like to pick up on 8 points arising out of my learned friend's submissions yesterday. They're miscellaneous, but they're important. They include the misconception as to the limits of the liability to account as it was presented to you, and they also include misconceptions as to what was being said in Ewing and or Ewing in relation to claims being in personam, not in rem, and in particular as to what was being said in Lightning in relation to the limits of claims which can be brought in personam, not in rem. The point about Lightning, contrary to what my learned friend was saying to you yesterday, is that Lord Justice Peter Gibson was saying on 2 occasions that the in personam, not in rem jurisdiction is limited in circumstances where property comes into the hands of the third party and title is extinguished by the lex situs. But we'll come to that. So that's going to be the second heading. The third heading will be to look at the key authorities, and they begin with Acres, and they follow on with Macmillan and Lightning and Alarjou in conjunction, the key authorities in relation to this particular point. And then, fourthly, so far as time permits, to deal with other matters. But as a general comment, I'd ask your lordships to take as read our written case in relation to this, which naturally will.
We always take account of parties' written case,
of course,
when we come to write judgments.
And I appreciate
so
that.
Unless a party wishes to depart from part of the case, then you have the written case as well as your oral submission.
Indeed, my lord, and forgive me, I didn't doubt it. But the written case, our written case incorporates answers to points which were not articulated yesterday in oral submissions by my learned friend, as well as points which were articulated by my learned friend and which I'm unlikely to have time to deal with, for example, land registration.
Sure.
Can I just raise a couple of points, if I may? At some stage, I would like to come back to your explanation given yesterday about the splitting of legal and equitable title. There's also an authority that neither party has yet referred to. I almost mentioned it yesterday. But it's the Criterion Properties in Stratford case, 2004 UKHL 28 House of Lords case, dealing with Akindele. And we would, I think, be helped by submissions, whether orally or if not, in writing afterwards, as to the significance of anything of that decision.
Indeed, we are aware of it. It's where Lord Nichols, in paragraphs 3 and 4, rationalised the case as a want of authority case.
Yes, yes. He saw the matter as a question of the law of agency rather than any question of unconscionability.
Certainly on the facts of that case.
Yes.
Yes. Well, no, we're on to that. Thank you. So far as regards the point of principle, the feature of knowing receipt claims for which the respondents contend, and it might be treated almost as a chapter heading to what I'm about to say to you, was expressly recognised by Lord Nichols in his new landmark article. And if I may take it as the chapter heading, if you would go to page 2441 of your electronic bundle, you'll see in the final paragraph on that page the following sentence in relation to liability and name receipt. Thus, the cardinal feature of this head of liability is the wrongful receipt or retention of property in which another person, a beneficiary, has a subsisting equitable interest. And whilst we've got this article open, just to pick up page 2453, These are points made in our written case, but with respect, it's worth seeing them, as it were, live.
2453.
Please. 2453. So this is in the concluding passage to the article where Lord Nichols is conjecturing and commending a new landmark approach. And he says of the principle of strict liability for which he contends in the third sentence, this would be a principle of strict liability in that it would apply to every recipient with an impeachable title, irrespective of fault. So,
sorry, which paragraph?
we're looking at the
Bottom paragraph.
The bottom paragraph, sorry.
Yes, the bottom paragraph, and it's the third sentence.
Ah, yes.
Yeah.
In fact, it's the fourth sentence, I apologise. So even in relation to the new landmark approach, impeachable title was regarded as a matter of importance. But clearly the fundamental point is the one which comes from page 2441. This isn't simply Lord Millett. This is also, when one's looking at members...
Certainly isn't Lord Millett.
Sorry?
I said it certainly isn't Lord Millett.
No, this isn't only Lord Millett.
Oh, I see.
What I was trying to say, my Lord.
Yeah.
When one looks at there is another member of the House of Lords who has written influentially in this particular area. This is an article which is treated with very great respect, who states what we regard as, with respect, the blindingly obvious, namely that a subsisting equitable interest is necessary if you're going to hold a third party to account, because that's the fundamental nature of being able to bring a claim based on the proprietary character of an equitable interest against a third party. But let me develop the point. The respondent's point is this. As a matter of principle, from whichever end of the telescope the present issue is approached, the answer is the same. And that's that the Court of Appeal and Mr. Justice Fancourt got the answer right in this case. Whether you approach the issue from the standpoint of the source of a beneficiary claimant's standing to bring a claim in knowing receipt against a third party, so whether you approach it from the end of the telescope of the standing to be able to bring a claim in knowing receipt, or whether you approach the issue from the standpoint of the remedy conferred on a claimant in knowing receipt, the answer is that the claimant is relying on the third party having taken property subject to that beneficiary's pre-existing equitable interest, not pursuant to a disposition under which such pre-existing equitable interest was overridden and so extinguished as against the third party. As to the former standpoint, the standing standpoint, that can be embodied in two propositions. Proposition 1, the right to bring a claim in knowing receipt does not exist in a vacuum. It is a right which is an incident of the beneficiary's equitable interest. It attaches to it. It, if you like, is appurtenant to it. It is an incident of the beneficiary's equitable interest. Proposition 2. If the third party has taken an absolute title free of such equitable interest, then the third party has taken free of any right of the claimant to bring a claim against the third party in reliance on the rights attaching to such equitable interest. You've taken free of the equitable interest, you've taken free of the rights which are an incident of that interest, and the rights which are incident of that interest include the right to bring a claim in knowing receipt. These propositions apply to a proprietary claim that might be brought by a beneficiary. That needs to be based on his continuing to be entitled in equity to property in the third party's hands. And it applies equally and for the same reason to any knowing receipt claim that might be brought by a beneficiary, which is likewise based on the beneficiary's equitable interest and the rights attaching to it. Each claim, whether proprietary or in knowing receipt, depends on enforcement of the beneficiary's equitable interest as against the third party, and each will be defeated if the third party has taken free of the equitable interest. This is the position if the reason why the third party has taken unencumbered title is on an application of the English bona fide purchaser rule. That is, both proprietary claims and knowing receipt claims are impossible as against a third party in such a case, including in relation to knowing receipt claims, including in a case of after acquired knowledge. See Lewin on trusts on this. The references are at paragraph 19 of our case. It's at page 116. Now, this proposition on which my Lord Briggs pressed the appellants yesterday contains within it an underlying truth. That is, and that truth is that a claim in knowing receipt does require a continuing subsistence of the equitable interest in the property in the third party's hands at the time that the requisite knowledge is obtained. The fact that such a claim is utterly barred and prevented by bona fide purchase for value without notice contains the underlying truth that if the equitable interest has been overridden, that's the end of the story. The present case is simply another example of this, where the relevant rule governing priorities in relation to the property in question, as supplied by the Lex Citus, is not the English bona fide purchaser rule, but another rule, which provides for the taking by the third party of an absolute title, free of any continuing equitable interest of the beneficiary in the property in question. The two situations, bona fide purchase for value without notice and a system of registration under which the beneficiary's equitable interest is overridden, are indistinguishable, and the logic that they produce the same outcome is, in our submission, irresistible, with the greatest of respect. Now, that's to look at the matter from the standpoint of the basis of the beneficiary's entitled to claim. That's looking at it from the standpoint of standing to bring a claim. But similarly, if you're looking at it from the latter standpoint, the remedial end of the telescope, it is on the basis that the third party is holding property subject to the beneficiary's equitable interest when the knowledge of breach of fiduciary duty affecting his conscience was obtained. It's on the basis that the third party is holding property subject to the beneficiary's equitable interest that the restorative and pending restoration custodial duties which characterize being liable in knowing receipt have a subject matter on which to bite. That the third party is subjected to custodial and restorative obligations in favour of the claimant in relation to property in his hands makes sense if the beneficiary has a pre-existing, continuing equitable interest in such property, in a way that it simply does not if the beneficiary's equitable interest in the property was extinguished on the third party's acquisition of it. The point may be said to be obvious, but nonetheless it needs to be expressed by asking how, as a matter of principled analysis, it can be said at one and the same time that, one, a third party has taken an absolute title to property so as to override or extinguish a claimant's equitable interest in the property, and yet, two, the third party owes custodial and restorative duties to the beneficiary in relation to the very same property. Custodial and restorative duties, which are part of the liability in known receipt, not simply of the very limited conception of an account which was put to you yesterday. Custodial and restorative duties make sense when it is recognised that the third party is holding subject to a beneficiary's equitable interest, that is subject to the beneficiary's trust rights over the property in question, in respect of which a duty to restore and custodial duties in the meantime arise. They don't make sense, those duties, if the third party has taken free of the equitable interest.
Isn't too crude a way to put it to say it makes no sense to impose a custodial or restorative obligation on someone who can say, in relation to the property in question, it's mine?
It's not too crude. It's not. It is the point in this case. I mean, this point is actually, in our respectful submission, viewed as a matter of principle. Very straightforward point.
Well, even in terms of an account, if an account involves giving an explanation, why should you have to explain what you've done with your own property?
Precisely.
If nobody else has any interest in it.
Precisely. And you say to the person, it's not your property, and now you want me to give an account. I mean, even on my learned friend's very limited notion of account, you want me to give an account of the financial dealings with it, and you want me to pay compensation in relation to it, but it's not your property, it's my property. Now,
can I just ask you,
yes,
the terminology of custodial or restorative, what exactly is it that we're required to do?
well,
If you're required to restore it, what is the custodial element at that point? I mean, what do these terms mean?
what they mean, we're going to come on to that, my lord, but
Well, don't let me take your answer.
No, please, forgive me, it does, obviously, with respect, it merits an answer. What's being said, I think, is this, that once you have the requisite knowledge, that in a case where applying the Akindele principle, it's become unconscionable to retain the benefit of the receipt, because that's the principle. It's not, with respect, unconscionability or wrong of receipt. The test is unconscionability of retention of the benefit of receipt. That's what Akindele says. That's what the Privy Council said in Arthur. Yeah? Unconscionability of retention of the benefit of the receipt. And the point is this: once you've got the requisite knowledge, you've got the custodial duty to keep the property safe. Then, when someone asks for you back, asks for it back, then you've got the restorative duty to give it back. And if you don't do either of those, if you don't keep it safe, and or you fail to restore it when you're asked for it back, or indeed you fail to restore it having not been asked for it back, yeah, and you go on to dissipate it, to damage it, then you are liable, just as an express trustee would be liable if they treated the property in their hands without proper respect for their duties. So that's what it means. It means what it says, and we'll look very briefly at
You have to be asked to give it back, do you?
You don't have, no, I think once you know, then you should be restoring it, but in the meantime...
And what about before you get it? You say nothing kicks in, in the sense until you've received it, but if you know that you are going to be receiving property, isn't there a duty in which there's beneficial interest enjoyed by the claimant, aren't you under a duty not to receive it?
There may be all manner of fact situations which need to be investigated as to your degree of understanding. But in a case where you shouldn't have taken it, you shouldn't have taken it. But if you want to put the obligations in terms of custody and restoration, those obligations, which are the obligations centrally recognised, can only kick in when you actually got it.
Yeah.
So what's the remedy to stop you receiving it? That's an injunction.
Yeah.
Yeah? Okay. So can we come back to that insofar as necessary?
Yes, I'm just trying to clarify what exactly the duty is. I mean, at one point I understood you to be saying, well, you've got to be asked to restore it, whereas I think you're now accepting, no, your duty is to restore it. In other words, as soon as you get it with the knowledge, you should be handing it back, so to speak.
Yes, my lord. I wasn't changing position. I was just developing the thought. It is yes. You've got the moment you've got it with the knowledge, you've got custodial obligations.
Well,
yeah, you should be handing it back. If you don't, those custodial obligations will be held strictly to account in the way in which you deal with the property. If you're asked for it back, certainly you should hand it back. That's the position. It's no more complex than that, but obviously in relation to the facts of any given case, they would need to be investigated in order to form judgments about people's.
So what I'm saying is the custodial duty only applies if you failed in your restorative duty.
Oh, correct.
Yeah.
And so long as
that only applies if you failed in what I would consider the primary duty, which is never to receive it in the first place.
well, my lord, but you know, as we know, knowing receipt cases can include cases of after acquired knowledge.
Yes.
And you know, well, you've got the point.
It's just a case of trying to articulate what the wrong is, actually.
Well, the wrong as established in Akindele and as affirmed by the Privy Council in Arthur, obviously neither is binding on this court, is articulated as unconscionable retention of the benefit of the receipt.
Yeah.
And there is no, we would suggest, no reason to depart from that in order to deal with this particular case.
In receiving the property, you might commit another wrong, which would be assisting the fiduciary.
Indeed.
And if you do that dishonestly, then you're liable in that way.
Yeah.
Yes, and of course, and that's right, if you're receiving the property, but I don't want to go off on too much of a tangent, but of course you'll appreciate, if you're a pure dishonest assister and you don't receive the property, you don't have a custodial duty and you don't have a restorative duty.
No, it's a different
You do
wrong.
have a liability to account, and that's the full panoply of remedies in liability to account, including, as I'll come on to, compensation for loss, which is one of many of the remedies available under this heading. Now, may I come back to where I was going? So, Williams, although it features large in Maloney and Friends' case, it featured quite small in his submissions, Williams does not decide the present case. It's got nothing to do with what we are addressing and nothing that we are saying is inconsistent with it. On the respondent's case, the custodial and restorative duties of a knowing recipient and the remedies flowing from them are not based on the knowing recipient coming to hold property on a constructive trust. The remedies recognise and are fashioned around the fact that the third party is holding what is already property in which the beneficiary has a retained equitable interest, and that if and when, but not before, the third party has the requisite knowledge to bind his conscience, custodial and restorative duties are recognised in relation to that property accordingly. The equitable interest that we're keeping our eye on, the thing to keep is keeping one's eye on the ball here. The equitable interest what you need to keep your eye on is the equitable interest under the true trust, in respect of which there's been a breach of fiduciary duty. It's not any equitable interest which we are suggesting, contrary to Williams, is conjured up on granting the remedy of knowing receipt. We all know that that as a result of Williams and Paragon Finance before it, and Selingall before that, that the liability to account is a liability to account as if you are a constructive trustee. But we're not suggesting that liability in knowing receipt is dependent on being on a constructive trusteeship being raised in relation to you as a result of becoming a known recipient. What we're saying to your lordships is that the relevant trust, the trust in respect of which you've got to look to which you've got to look for the equitable interest, is the pre-existing true trust which has been breached by the fiduciary, and you have to ask yourself the question in relation to that equitable interest: has it survived? So the formula for relief point in...
So on your proposition, it doesn't actually matter whether we describe the knowing recipient as a constructive trustee, or are you actually saying positively we do not need, we shouldn't be describing it?
You shouldn't be. I mean, there's absolutely no reason for your law.
That doesn't make much sense in the director's case, though, does it?
But it does, my lord, if you're... Sorry, what doesn't make much sense? Forgive me.
Saying he's a true trustee, I mean, well, it all depends what you mean by true, but
look,
you're inventing a trust there, and it doesn't really matter for your argument, because either way, it requires some property interest at some stage, which is inconsistent with the proper law in this case.
That's true, my lord, but the fact is that the trust in the director's case is, in the nature of a constructive trust, as I was saying yesterday, raised as between the director and the company. That's the analogue to the true trust. And I am going to come back to this.
But absent the misbehaviour, as it were, absent the breach by the fiduciary of his duty, is there a trust relationship between the director and the company? And is the company the beneficiary of a trust?
And the authorities suggest that either the answer to that is, for this purpose, yes, generally, or, and I'm going to take you to Lord Justice Kay in the land allotment case, the explanation is precisely the explanation I gave you yesterday, that where property is in the hands of someone who is a fiduciary and they misapply it, they breach their fiduciary duty, on the occasion of that act, there is a severance of the legal and equitable interest.
Yes, well, that's different. That's precisely the point I'm making, that what is being said in Belmont Finance by Lord Justice Buckley seems to be that it is on the misapplication that the trust relationship arises, that a fiduciary, like a director, is not in a trust relationship if he or she is behaving themselves, but the analogy with trust arises on the point of misbehaviour, because with the passage that you helpfully referred us to yesterday draws on the Master of the Rolls Jessel in Russell. But Russell, of course, was a case about the proper plaintiff rule, and Lord Justice Buckley has taken part of that Jessel's judgment it seems, to set up the existence of a trust arising on the misapplication of the funds.
Lord, yes, which is precisely what I said to your lordships yesterday. And my point is...
Well, yesterday, yes, but today you seem to be saying today, and Lord Leggett was picking you up on that, as am I, that there is a pre-existing trust, pre-existing the breach of fiduciary duty.
No,
now,
that's
is
not.
There or isn't there?
My lord, that's that. No, what, my lord? That's what. In relation to the true trust case, there will be a pre-existing equitable interest. Yeah? Clear.
This is a true trust case, as it happens.
As it happens, this is a true trust case. Okay. In relation to the director's cases, which do require a degree of rationalisation, the rationalisation which I provided to you yesterday is, I would suggest, the correct rationalisation, which is that at the moment of the breach of fiduciary duty, there is a severance of legal and equitable title in order constructively to confer on the company the same sort of protection as would be available to a beneficiary of a trust. It's an extension of the remedy. There is a severance. At that moment, the company has an equitable interest. And the question then is, in relation to the third party, whether that equitable interest was extinguished on the occasion of the receipt by the third party. The third part, that's the point.
Which I can see, once you've set up the equitable interest, I can see the point. You've got the third party purchaser for value, and you have the effect of Saudi law in this case, and you say it's all the same. But before Belmont Finance, was there any other case analysing the law in this way, that there was a deemed creation of a beneficial interest in the company at the moment of breach?
Yes, Lord Justice Kay in land allotment.
Well, if you're coming to it, come to it when you wish to.
I was going to.
As long as you come to it at some point.
I will. But if your Lordship's obviously very focused on the Belmont Finance passage, you'll actually see in the Belmont Finance passage, in parenthesis, re-land allotment is actually invoked by the court.
It is indeed.
Yes.
And so does Mr. Justice Ungo Thomas in Selangor.
Where the explanation to which your Lordship drew attention to yesterday actually goes on for a further 3 pages.
Yes.
And which includes the quotes from in particular Lord Justice Kay, but also Lord Justice Lindley, and I think it's under Master of the Rolls.
He quotes all the key passages,
all the key passages.
Russell.
Precisely. But your Lordship's all over this.
I would characterise he's feeling the way,
Yes.
and Lord Justice Buckley sort of puts the nail on it.
Yes.
Yeah.
Well, he does. And actually, the same point is made. Look, we're talking about it now, and I have limited time, so let's talk about it finally. But
can I just, before you take us to the authority, that's a constructive trust in your view. The severance of the legal and equitable title at the moment of the breach of fiduciary duty is what? Is that a trust?
It's a trust imposed by law, isn't it? So it can only be a constructive trust.
So it is a constructive trust?
Yes, it can only be. It's a very particular example of the jurisdiction in action.
I mean, it all depends what you want to call things, doesn't it? You could reserve the label of true trust for any time there's a split between equitable and legal interest, or it could be somebody's assumed responsibilities as a trustee. I mean, well, there's no such thing as a true trust metaphysically. It's how it's all creations of the law in one way or another.
Yes. Yeah. But your key point, as I understand it, is at the moment of breach, there is this severance of legal title and beneficial interest.
Indeed, that's right. And it's
whatever we label it.
My Lord, that's absolutely right.
Yeah.
Yes, and as my Lord Lord Briggs said, all the key passages are quoted in Selangor at 1857 to 1859, including the lands allotment passages. And if we go to there's one other reference I want to give you to, predictably, Mr. Justice Millett. The discussion runs all the way. Lord Briggs referred my learned friend to the discussion beginning at 1857. It runs all the way through to 1859. Yeah. And the way in which I put it to you yesterday is embodied in the last sentence of Lord Justice Kay in the middle of 1859. Last 2 sentences. As directors, they're not trustees at all.
So this is paragraph 1859, page 1859.
Yes, please.
Yeah,
1859.
Yes.
You see, Lord Justice Kay, the last 2 sentences of Lord Justice Kay. As directors, they're not trustees at all, so he doesn't regard it as a true trust analogue. They are only trustees qua the particular property which is put into their hands or under their control, and which they have applied in a manner which is beyond the powers of the company, I conceive that qua such fund, they are constructive trustees or trustees by implication of law.
Yeah.
That's the answer that we would incline to give. But however your lordships rationalise it, it's perfectly clear that this is operating by analogy to the position in relation to true trusts, and that what I've said in relation to true trusts, with respect, applies equivalently to these cases. The other authority which is interesting to look at actually is Mr. Justice Millett in Agip, and that's at page 686. It's the paragraph between D and F, and the particular passage is between E and F. He took advantage of his possession of them to divert the. Forgive me. Yes, he took advantage of his possession of them to divert the money and cause the separation between its legal ownership, which passed to the payees, and its beneficial ownership, which remained in the plaintiffs. There is clear authority that there is receipt of trust property when a company's funds are misapplied by a director, and in my judgment, this is equally the case when a company's funds are misapplied by any person whose fiduciary position gave him control of them or enabled him to misapply them. So that's a combination of Lord Justice Kay in Land's allotment and Mr. Justice Millett in Agip is supportive of the way in which I've rationalised it for your lordships.
And we see that concept of control loud and clear in Selangor and Belmont and all those passages cited.
And that was in the context, Mr. Justice Millett, of trying to understand what happened at the start of equitable tracing.
Lord Virginia informs me, yes.
Right. Well, you might say that was supportive of your case in that you were drawing a clear combination between the proprietary remedy and the personal remedy. If one's got the same puzzle, if you like, about what has to happen at the start of the tracing process, it might be said to be supportive of what you're saying.
Yeah. Well, because you've got Mr. Justice Millett, as he was, point that proprietary claims, tracing claims, as they were called, and claims in name receipt, both depend on property.
Yes, and it might help us understand what Lord Justice Hoffman was saying in Agip when he says traceable twice as part of, in Elajou, when he says traceable and twice as part of his explanation of what the basis of the claim is.
I'm so grateful to your lordship for having made that point, because it was a point I was going to make, that it's very...
You shouldn't be grateful at all. You should be thoroughly cross that I've stolen your thunder.
No. Well, it may, only if it's a good point, of course. But it was a point I was going to make. It's really interesting, this, because the Court of Appeal said, in relation to that 3-ingredient test in Elajou, when you look at the second ingredient, you may say there's an ambiguity as to whether the property stops at the door or actually crosses the threshold. But if you look at the third ingredient in Elajou and you incorporate the wording of the second ingredient into the third ingredient, it's perfectly clear that Lord Justice Hoffman is saying that it's the same property, the same interest of the beneficiary that has to exist in the hands of the third party. You have to be able to trace not merely to the door, but into the hands of the third party. So, if I don't get to it by 3:42 today, if I don't get to it, I implore your lordships to do that exercise of going to Lord Justice Hoffman in Elajou and going to the second ingredient and cutting and pasting what he says in the second ingredient into the wording of the third ingredient, and you've got the answer to this case. So, in summary, Williams has nothing to do with the issue in the present case. In the position, you've already got it, my lords, but I would summarise it in, if you like, in 6 sentences. In summary, the respondent's case, number one, the respondent's case before this court is not based on the proposition that the consequence of holding a third party liable in knowing receipt is that the third party becomes a constructive trustee. Proposition 2, the respondent's case is that it is not possible for a third party to be liable to be made liable as a knowing recipient in the first place, and so be liable to account as if a constructive trustee if the third party has taken unencumbered title to the property in question. Proposition 3, the trust upon which the respondent is focused is not any inaccurately labelled constructive trust said to arise if knowing receipt is made out, but the pre-existing true trust, in trust cases, the pre-existing true trust which has been breached by its true trustee in making the property transfer complained of. Extrapolate to directors.
So just could you go through proposition 3 again, please?
Oh, I'm sorry, forgive me. The trust upon which the respondent is focused is not any inaccurately labelled constructive trust said to arise if knowing receipt is made out, but the pre-existing true trust which has been breached by its true trustee in making the property transfer complained of. And then obviously, my lords, extrapolate to directors. We've had that conversation. Proposition 4, it's under that true trust that a beneficiary claimant has an equitable interest. Proposition 5, the right...
Slow down, please. If you're wanting us, if these are key components, we want to note them. It's under the true trust, proposition 4.
Proposition 4, it is under that true trust that a beneficiary claimant has an equitable interest.
Yes.
Proposition 5, the right, if any, to bring a claim in knowing receipt against the third party is an incident of such beneficiary's equitable interest in the property, being property owing its trust property status to the pre-existing true trust. And 6, custodial and restorative obligations bite in relation to such property in the third party's hands because of the beneficiary's retained equitable interest in it, and they're not the result of any actual constructive trust arising for the first time under the doctrine of knowing receipt. And nothing in Williams calls into question the validity of these propositions. Yes. As you know, Williams was concerned with a quite different question, namely the proper classification of a claim in knowing receipt for the purposes of determining whether it fell within Section 21(1) of the Limitation Act. And Williams confirmed that Section 21(1) was only concerned with true trusts. That is essentially two-party situations involving the trustee-beneficiary relationship in cases where trusteeship has either been reposed in a particular person or has been assumed by a particular person constructively. But where duties are recognised by a court in relation to a third party in an ancillary liability case, Williams confirms that that second class of case is not a constructive trusteeship strictly so called. It is not a true trust. Now, contrary to my learned friend's submission to you yesterday at pages 151 to 152 of the transcript, the respondent does not say, and has never said, that Williams only held that a knowing recipient was not a true trustee for the purposes...
Could you speak up a little bit, please?
Sorry.
The respondent has never said...
The respondent has never said that Williams only held that a knowing recipient was not a true trustee for the purposes of Section 21(1). That's never been our submission. Williams decided that Section 21(1) is only concerned with true trusts. And so-called constructive trusts of the second class, that is, cases of knowing receipt and dishonest assistance, are not true trusts. That's what it decided. And we fully accept, indeed, well, personally, if I may say so, what I've always understood in all my years of practice, that in order to be a true trust, there has to be, it's a two-party situation where trusteeship is either reposed in somebody, excuse me, or they have assumed office. They've assumed the office of trustee so as to create the equivalent relationship as if a settlor had reposed trusteeship in them. That is true trusteeship. Everything else is outside of that. Williams confirms it and applies it in relation to Section 21(1). The Court of Appeal had previously done the same in prorogant finance. Indeed, we'd suggest, forgive me, there is a tension in this aspect of the appellant's case. Because if the custodial duty and the beneficiary's correlative rights against the third party are not based on the third party holding pre-existing trust property, then the custodial duty and the beneficiary's correlative rights against the third party must be based on newly recognized trust rights binding on the third party. And that would suggest that the court is introducing a new trust, a constructive trust, where there wasn't one before, which is the opposite of what was held in Williams. So if you've got custodial duties, if you've got restorative obligations, it only makes sense to say that if you've got existing trust property, existing trust rights. If the beneficiary's got rights as against the third party, which are assertable by reference to an equitable interest. If the equitable interest has been extinguished and you can still bring a claim in knowing receipt, where have the rights come from? The rights must be being invented by a court. That suggests a constructive trust, and Williams says, no, that's wrong.
Can I just be absolutely clear? So the knowing recipient, on your view, I may have already asked you this, I'm not sure what the answer was. Are you saying that knowing recipient is or is not a constructive trustee?
Is not.
Not a constructive trustee, even though, in the director's case, you would say that there was a splitting of legal and equitable title, and in our case, even more obviously so. So why is the knowing recipient holding the legal title separate from the beneficiary still with the equitable title? Why is that, given what you said before about the splitting of legal and equitable title, a trust?
Yes. Well, we deal with this. I'm going to come on to this now. We deal with this actually in Section F of our written case. That there is an oddity in the way in which the law has developed in this area, because once you recognise in the proprietary claim context that a proprietary claim lies in circumstances where the equitable and legal title have been severed and the third party is holding legal title subject to an equitable interest, it's possible to say in that case, well, let severance of legal and equitable title, you hold on trust. Right? Now, if you say that, then everything else potentially follows from that, because you are a trustee and you don't need the law of knowing receipt in order to make you liable if you commit breaches of that trust. But
that isn't your case.
No, but it's not the way the law has developed. The way the law has developed is, and I'm going to come to this, is to say that you only have the, as it were, the obligations equivalent to trusteeship imposed upon you or recognised in relation to you when you have the requisite knowledge. And it's only at that time that the obligations equivalent to being a trustee are imposed on you. This is dealt with in Section F, but can I give an overview of what we say in relation to the law of knowing receipt in relation to this?
Just trying to get clear. So I realise that these propositions are put forward in relation to the Williams case, and that was what you were specifically addressing. But within the context of that Williams case, you've given us a distinction between what you've classed as true trusts and other types of trust. But you've also told us that in order to make out your case in relation to directors, you have to accept that the director is, at the point of breach, a constructive trustee.
Because he owed a fiduciary duty,
Yes.
which he breached, which
Yes.
the third party...
Now, is that a true trust on the Williams analysis, or not?
What, the director case?
Yeah.
No, because it depends on terminology. But I would suggest is not a true trust, it's a constructive trust, and the authorities suggest it's an implied or imposed trust.
Right.
Because the trusteeship was not actually reposed in the director. That you wouldn't have said prior to the breach of fiduciary duty that the director, in drawing up his accounts, would be showing ownership of all the assets of the company. The circumstance in which the trusteeship is conjured is the circumstance of breach. So I think that if you're looking for indicia, hallmarks of whether it's a true trusteeship, you might say that what I've just said is an indicator that it's not. I would say to your lordships that in the director case, it's not a true trusteeship, but for the reasons which I've given to my Lord Hodge a little earlier, doesn't matter. Because the important point is the point which is made by Lord Justice Kay, the point which is made by Mr. Justice Millett, that you've got the severance of the legal and equitable title at the key moment.
Yes, I mean, if you have the beneficial interest separated from the title, it really doesn't matter what you call the recipient.
Yes.
As long as you have a proprietary interest on which to mount the claim for knowing receipt.
Yes, and indeed,
And you say if that's wiped out by Equity's Darling or Saudi law, that's the end of the story.
Indeed.
That essentially is the case.
that is essentially the case. But I, with respect, I do understand exactly where Lord Burrows is coming from. If I can say so, I'm sure you've been there before me and will continue to be there after me, my lord. But it's what we say in Section F. Yeah, there is. You could take the view that the whole law of knowing receipt is a misconception, because you could take the view, yeah, that if you've taken property subject to an equitable interest, yeah, then you're a trustee, and then everything you do in breach of duty thereafter gives rise to liabilities.
But that goes further than equity has gone, so far as personal liability is concerned.
Precisely, and you don't need to go there.
Yeah.
That's the sort of Mitchell-Watterson approach, is it?
No.
No.
No, in fact, if you look at what Mitchell and Watterson say in relation to this, it's very, very limited. And, for example, if you look at Mitchell and Watterson, they do not take issue with, this is the litmus test, they don't take issue with Paragon Finance, which had already been decided. They're not suggesting that when you speak of, and they use the expression, accounting as a constructive trustee rather than accounting as if a constructive trustee. They're not suggesting that Paragon Finance is wrongly decided. They're saying the reference to constructive trusteeship is bringing something to the party, and what it brings to the party is an understanding of the measure and nature of the liabilities to account. Because what they're saying in their article, and it's a great article, what they're saying in their article is, if you want to know what the liabilities of a knowing recipient are, just ask what the liabilities of an express trustee are, and we'll tell you what they are, and then we'll give you lots of authority.
You've been very careful to say it's a liability as if a constructive trustee.
That's making the law a bit complicated, isn't it? Once you have not only a constructive trust, but something as if it's a constructive trust, you've got kind of two layers of fiction built into that.
I'm not appealing, Williams. But
But all I was going to say was, you were making the point as if a constructive trustee. My understanding of the Mitchell and Watterson article, they were saying the knowing recipient is a constructive trustee.
well, we would suggest, my lord, that it doesn't go quite as far as that. I mean, we would say that what they're saying is that the reference to constructive trusteeship actually does bring something to the party in order to explain the nature of the liabilities that are imposed. But they're not saying that this person is a true trustee in the sense of Williams. You will not find any suggestion in Mitchell and Watterson that they are disagreeing Paragon Finance, and you don't find any suggestion in Goff and Jones, which is post-Williams, that they're saying that when they say, well, you know, with respect, we think that something is lost by not referring to constructive trusteeship. They don't go on to say, and so Williams was wrongly decided. Yeah? Well, they're making a very limited point, and the number of occasions where they actually make the point in what is a 30-page article are few and far between. And what you can say with certainty is that whatever you think of the way that they've expressed themselves in those one or two sentences, yeah, what that article tells you about the liabilities, the actual liabilities of a knowing recipient, is correct. So whatever explanation they may give of how they see it, the fact is that the detailed narrative of what it means in terms of liability to be a knowing recipient is laid out in that article. It's laid out comprehensively and definitively. It's the best treatment anywhere of this subject. And it's certainly not to be binned for their personal view, such as it is. And I really would suggest that the article's read with care in relation to this, as regards terminology. It's not a substantive point on terminology. It's a this is helpful to your understanding point on terminology. I mean, the way we think the law stands in relation to the point that we've been debating, so that's taking knowing receipt at face value, is this. I mean, unifying the points which are made in section F of our written case. What one needs to bear in mind in relation to the cases referred to in section F, and what I'm about to say, is that the courts which have debated these points were sometimes operating in an environment and using language where knowing receipt was being described as constructive trusteeship. So some of the old cases, they were saying that. Indeed, probably we learned that was the case when we were students.
I think we did, yes. It's that sort of box analysis in one's dim recollection.
So if and when such courts said that once you have knowledge that you're holding trust property, you become a trustee of such property, what they were actually saying, viewed through post-Williams spectacles, was that once you have the requisite knowledge, you have liability to account as if constructive trusteeship had been imposed in relation to you. So when they were talking about the requisite knowledge for constructive trusteeship, post-Williams, in Williams speak, we say the requisite knowledge to have to be liable to account as if you were a constructive trustee. Bearing that in mind, we can unify the points made by us in section F as in two propositions. First, and I'm going to take, and Lord Brown-Wilkinson is the authority for this, and I'm going to start with Foskett and McEwen, although we refer to him making the same point in Westdeutsche, but Foskett makes the point very clearly. The first proposition is what Lord Brown-Wilkinson said in Foskett and McEwen at pages 1295 to 1296 of the bundle, pages 108F to 109D of the report.
1295.
It is 1295 to 1296. I'm not going to turn it up, but for the purposes of making the point that I'm about to make, but of course your lordships may find it helpful. So first, as what Lord Brown-Wilkinson said in Foskett at those pages, culminating with his reference to hard-nosed property rights. That is, that the beneficiary's proprietary claim is based on saying, that is mine in equity, give it back. And that claim does not rely upon an analysis which requires the beneficiary to say to a third party, you are a trustee holding on trust, hand it back. Okay, so the hard-nosed proprietary rights claim is, that's mine in equity, hand it back. And it doesn't rely on saying, you are a trustee holding on trust, hand it back. That's the Lord Brown-Wilkinson view of the world. And in those pages. And it echoes what Lord Brown-Wilkinson had said in Westdeutsche at page 2078 of the electronic bundle, at page 707 C2E. And perhaps that is worth turning up, because...
Did you say C to E?
Yes, please. 2078 C2E. It's I think the reference that we had in mind when we wrote section F. But it's the same point as Foskett. I mean, it's an interesting read. The bank contended that where under a pre-existing trust, B is entitled to an equitable interest in trust property, if the trust property comes into the hands of a third party, X, not being a bona fide purchaser, B is entitled to enforce his equitable interest against the property in the hands of X because X is a trustee for B. In my view, the third party, X, is not necessarily a trustee for B. B's equitable right is enforceable against the property in just the same way as any other specifically enforceable equitable right can be enforced against a third party. Even if the third party, X, is not aware that what he has received is trust property, B is entitled to assert his title in that property. If X has the necessary degree of knowledge, X may himself become a constructive trustee for B on the basis of knowing receipt. But unless he has the requisite degree of knowledge, he is not personally liable to account as trustee Montague. Therefore, innocent receipt of property by X, subject to an existing equitable interest, does not by itself make X a trustee, despite the severance of the legal and equitable titles. And then he says, well, not everyone may agree with this terminology, may be a question of semantics, and it's a point made in section F. But this is terribly interesting, isn't it? It's using language which is precisely the language of the submissions that I've been putting to your lordships, that we're talking about something being trust property in the hands of B, and the being subject to an existing equitable interest in the hands of B. And this is, and then Montague being seen as, or being cited as authority for the proposition that the additional element of knowledge is necessary if knowing receipt is to be made out. And with the greatest respect, this is absolutely right in terms of, as it were, conventional analysis. But it reinforces precisely the case we would respectfully submit that we're putting to your lordships. Now,
to be changed to as if a trustee after Williams.
Yes.
Yeah.
Yes.
I mean, in the back of my mind, a dictum of Lord Brown-Wilkinson in Target and Redferns. Is it Target and Redferns where he does come quite near to saying, wherever you have a severance of legal and beneficial, you must have a trust. I mean, here he's absolutely not saying that.
Yes. And indeed, you know, to be fair, look, in section F, we've actually said that there are two schools of thought here, and we point to the discussion in the ITF case, the Noble case, where it's suggested by Lord Justice Lloyd that, in fact, you do have a trust when you've got severance of legal and equitable.
But the trouble is there's just different usages of the word, and what really matters is what obligations attach in what circumstances, not whether you choose to call someone a trustee or not call them a trustee, or to call them a constructive trustee, or someone who's in a position as if they were a constructive trustee. What actually matters is when you have a situation in which something has happened and you have a degree of knowledge or you don't, what obligation do you have?
That's right. And with respect, we tried to say that in section F. The real question is, and Mitchell and Watterson say this, you know, you can argue semantics, you can argue terminology till the cows come home, but the real question is, how did the obligation arise? What does it consist of? What has it been breached? What are the consequences? And we say, for the obligation to arise, you've got to have taken subject to the equitable interest. That's the point. It's as simple as this.
And going back to the company situation, you say that as soon as the company director breaches his fiduciary duty by giving money away, treating it as his own, well, giving it away, there's a division of the legal and equitable interests. But who's the trustee? Who's the trust? Who actually holds the property?
Well, we're in scintilla temporis land, aren't we? Is it the moment when he forms the view that he's going to misapply it, or is it the moment when he misapplies it? So, what can be said with some certainty is the moment he misapplies it, there it goes. You've had a division of legal and equitable title.
But coming back to the point you're on, the vulnerability of a defendant to having to acknowledge a hard-nosed proprietary claim to enforce a continuing beneficial interest only depends upon him having notice of it. But the further claim to impose a personal obligation on him requires something more, namely knowledge, rather than just notice. And that's why, for example, a volunteer who takes property subject to an outstanding beneficial interest but disposes of it before the beneficiary catches up with him and does so innocently and without the requisite knowledge, even though by definition he must have the notice or the beneficial interest would have been cleared off. Well, not if he's a volunteer, but subject to that. He gets away with it in the sense that he doesn't come under any personal obligation to account.
Spot on. And forgive me, exactly, because you need the knowledge in order to have the custodial and restorative obligation imposed on you. Merely taking the property, this is straight down the line, Sir Robert McGarry in Montague and Lord Brown Wilkinson in West Deutsche.
So you have the vulnerability to a proprietary claim, providing there's notice, assuming you're a purchaser, providing there's notice.
Yes.
If you're a volunteer, you have that vulnerability anyway,
yes,
even if you don't have notice.
Yes.
But to have a personal obligation that goes beyond merely having to hand the property back. But then it makes all the more strange the assertion that a knowing receipt claim imposing a personal restorative obligation can exist where the claimant hasn't even got an outstanding beneficial interest. He hasn't got a proprietary claim, and yet somehow he's got this alternative one.
But one of the many points which I had, if I was going to have time, I was going to say to you, I mean, it's a variant of the how can you have taken free of an equitable interest and yet be responsible for restoring it. But one of the points which I was going to make to you, I'll make it now, is that you get into the weird territory where it's actually the territory of this very case. We still hold the disputed securities.
We've still got the shares.
We've still got them. And we had them, we've still got them, full stop. We certainly had them when the other side pleaded their case first time round and when they pleaded their case second time round. We still have them. They accept very, very reluctantly, a very steep hill to climb, that they have they couldn't mount a proprietary claim in relation to the shares. But they say, but we don't want the shares, we want their value. Now, isn't this a very weird situation? You'll be the pup, if I may call it that you're being asked to buy, is that they don't have a beneficial interest in the shares, yeah? So they can't call for the shares. But the fact that they don't have a beneficial interest in the shares is no reason why they can't call for the value of the shares. Really?
Or theoretically, could apparently impose a restorative duty on you to give them back.
Yes, but via lightning. Yeah. Yes, what they do is they go to the court, as in lightning, because this is what happened in lightning. They'd go to the court and they'd say, can we have a declaration that these shares are held on trust? In lightning, it was, can we have a declaration that this land in Scotland is held on resulting trust? Having got that declaration, can we have an order that the property is restored? Can we have an order that the receivers of LEC transfer the property to us, acting in personam? Now, this is. Thank you very much for the counter example, because it's another example of the point which I just made in relation to a money claim. In theory, they could say, they could ask for an order calling for the shares. In theory, on the basis of this analysis. But the fact is they can't. And the reason why they can't is the reason identified in lightning twice on page 38 of the law report, that if the lex situs has extinguished an in personam claim, then game's up. It's what I said to you right at the beginning this morning, and I said I was taking issue with what my learned friend had said to you yesterday. Everything that's said in lightning is said in the context of in personam claims. A recognition that you may have a claim to say that land in Scotland is held on resulting trust for me. Those shares in Saudi Arabia are held on trust for me. You may have a claim on the basis of that to say, personally, you restore them to me. But what's said in lightning, and it's said unambiguously, is such a claim will not lie if the lex situs has destroyed the equitable interest. And the same thing is said 7 times by the Supreme Court in Akers and Samba. Because in Akers and Samba, whilst we're on this, they're talking about exactly the same jurisdiction as lightning. At paragraph 34 of Akers and Samba...
Could you take us to it, please?
Okay. So Akers and Samba, paragraph 34... that'll teach me. It's not paragraph 34. Sorry. Let me get the reference up. I'm sorry. I'm so sorry. Paragraph 24, page 369. At paragraph 24, Lord Mance makes very clear the reason why Samba was bound to lose on what was initially perceived as the point in the case. And that is the Ewing and or Ewing principle that equities acting in personam, not in rem, in recognising the existence and enforceability of trusts, binding on the conscience of a party, in a 2-party situation, which was the issue in Akers, or indeed in a 3-party situation. Equity is acting in personam in both those cases. And my point is that the 7 references to in Akers and Samba to the lex situs being destructive of the possibility of a claim against a third party are all made in connection with this jurisdiction, the in personam jurisdiction. And indeed, as you know, paragraph 28 and onwards of Akers and Samba, 371, contains a unconditional endorsement of what Lord Justice Peter Gibson said in Lightning. In Lightning, Lord Justice Peter Gibson cites the very same jurisdiction. He cites the Ewing and or Ewing jurisdiction, the in personam not in rem jurisdiction, and he says, as is stated at 28, the two quotations. We only give Lord Mance one credit for one credit in relation to these two quotations. There are 6 other quotations in his judgment making this point. It's absolutely clear that the in personam jurisdiction stops at the door of an absolute title conferred under the lex situs, irrespective of the existence of notice. So to come back to the exchange which I was having with Lord Briggs, it demonstrates baldly, with the greatest of respect, the bankruptcy of the appellant's case here, because they are saying, they're recognising the shares, they recognise, because they've got to, that they've got no proprietary claim to the shares because their equitable interest has been snuffed out by the lex situs. But they say, notwithstanding that we've got no equitable interest, we are entitled to the money value of the shares. And then Lord Briggs comes back to me and says, well, it's actually worse than that. It's a Lightning situation, isn't it? They could, under the in personam jurisdiction, on the appellant's view, say, give me back the shares. And the answer to that is, no, they couldn't, because under the in personam jurisdiction, they're barred by the fact that title's been destroyed by the lex situs. That is paragraph 28 of Akers. It is Lightning, and it is said 7 times. It begins at paragraph 20 of Lord Mance, and it's said again and again and again. And since we've got it open, let's do it, if we may. The references, they start at 368. 368, please.
Thank you.
And you're very familiar with the quote at paragraph 20 of Lord Mance. But it begins, actually, the point is introduced at 18 and 19. And it's, if you don't mind, please just reading in, and particularly focusing on the last sentence of 18. So the last sentence of 18 is actually, frankly, an 8th reference, because our 7 references start with 20. So 18 and 19 of the introduction, and then it says, it is established by Court of Appeal authority, and was not challenged on this appeal, rightly, that where under the lex situs of the relevant trust property, the effect of a transfer of the property by the trustee to a third party is to override any equitable interest which would otherwise subsist, that effect should be recognised as giving the transferee a defence to any claim by the beneficiary, whether proprietary or simply restitutionary. Any claim by the beneficiary. I mean, it couldn't be clearer. And whether proprietary or simply restitutionary are clearly intended to be a comprehensive statement of what can fall under the rubric of any claim, whether proprietary or personal, plainly. And then Macmillan clearly being endorsed by the
Well, I mean, Lord Mance is relying on Macmillan for that statement.
Yeah.
Well, yeah, but yes, indeed he is, but he's doing more than that, my lord. Macmillan's a Court of Appeal case. Lord Mance is sitting in the Supreme Court. He could have said it's wrong.
Well, I mean, he's endorsing it.
Yeah. Oh, forgive me.
No, but
Sorry,
he said, and then you go on to Macmillan. But I mean, he makes the statement,
Yes.
colon, Macmillan.
Yes,
So
and
he's saying, I'm taking this principle from Macmillan.
And let's be brutally frank, the other side, and it is the other side, conceded this point last time before the Supreme Court, and they did so, and they were represented by Mr. Howard. They knew, and they had a bevy of Chancery counsel with him. They knew what they were doing.
And of course, it's terribly tempting to see Macmillan as a case where the claim was defeated by Equities Darling. But in fact, it was defeated by a tantalizingly similar provision of the law of the lex situs, which looked like Equities Darling, but actually it terribly mattered that it wasn't quite.
And that's yet another point. I mean, if only we had days to talk about this. That's yet another point. Yes, indeed, Macmillan is an example of a case where it's not the English bona fide purchaser rule. It's the lex situs, pure and simple. It just so happens that it was another notice rule.
Yeah.
What would, my learned friend would say, well, the fact is, yes, you're missing the point. Macmillan wasn't a known receipt case. Well, we'll see about that. Paragraphs, then we've got paragraph 21 and paragraph 22. This doesn't mean that a common law trust cannot or will not exist in respect of shares, simply because the lex situs may treat a disposition of the shares to a third party as overriding any, please underline any again, overriding any interest of the beneficiary in the shares. A trust existed in Macmillan in relation to the shares until they were disposed of under the lex situs by transfer to bona fide purchasers without notice, as my Lord Briggs just said, under New York law. Yeah, but then the point which Samba lost on, and obviously correct, a common law trust can exist in relation to property in civil law jurisdictions. Clearly it can, otherwise the law of trusts would be in disarray in relation to if you held if a trust held shares in a Swiss company and shares in an English company. Some would be held on trust, some wouldn't. A common law court concerned with Cayman Islands trusts, 22, in respect of Saudi Arabian shares, will give them their intended effect to the greatest extent possible, having regard to the overriding effect of any disposition under their lex situs. Absolutely clear. And then he goes back to the two-party case of Sickle and Mr. Al-Sania. And then you've got the point 24, where the explanation for the ability of the English courts to intervene and to recognise a trust in relation to property in foreign jurisdictions, including civil law jurisdictions, as my Lord Stevens was putting to me yesterday. The ability to recognise such trusts, which we fully accept and recognise ourselves, is traced back to Lord Selborne and Ewing and Ewing. We've looked at that. We've then got the discussion of lightning, and we've got the two propositions which you saw coming from Peter Gibson in paragraph 2028. And my learned friend, when he went to lightning, I think only took you to the second of those quotes, but the first quote is more brutal still. Not unnaturally regarded in English law as applicable to the relationship between the parties before it, in the absence of any event governed by the lex situs destructive of the equitable interest being asserted. And then the particular force of the second quote is that it actually mentions the transfer to the third party. In contrast, if the equity which is asserted does not exist between the parties to the English litigation, for example, where there's been a transfer of the property to a third party with notice of an equity, but by the lex situs governing the transfer extinguished the plaintiff's equity, the English court could not then give relief against the third party, even though he's within the jurisdiction. But in lightning, as Lord Justice Peter Gibson pointed out, no such event destructive of the equity had occurred. And then we've got the reference to paragraph 42, which is as part of a discussion of the effect of Article 11D, or of what is recognised under Article 11D of the Hague Convention.
Where are we now?
I'm sorry, I apologise, page 375. 375, paragraph 42.
42, thank you.
So at 42, the Lord Mance is saying that I'd regard the present trusts not only as intended to create, but also as creating equitable proprietary interests in the Saudi Arabian shares, enforceable at common law, at least as between Sickle and Mr. Al-Sania, and anyone else other than a transferee from Mr. Al-Sania in circumstances giving the transferee a good title under Saudi Arabian law. Paragraph 48, page 377. Equitable interests continue to subsist unless and until overridden by a transfer under the lex situs as recognised in Macmillan. Further endorsement. And then 51, page 378. It's worth reading the whole of it. Recognises that just because Mr. Al-Sania has committed a breach of trust, of course you've still got trust rights as against Mr. Al-Sania. Sickle have got that, unfortunately, that they weren't worth very much. But those protected trust rights will be overridden by a disposition of the legal title, under which it is the effect of the lex situs that the trust rights are overridden. And the same point is made at paragraph 54, page 379. Where the truth is then delivered to Sickle, which they are still not taking heed of in this appeal, is that if the disposal, this is the final words, if the disposal overrode Sickle's interest as regards a third-party transferee of the legal titles, such as Samba, that was not because of any disposal of Sickle's interest. It was because Sickle's interest was always limited in this respect. So again, the point is made again and again and again. It's a warning shot. And as your lordships have seen, and it was very briefly said by my learned friend yesterday, that the Supreme Court gave the appellants an opportunity to replead their case. But in giving them that opportunity, it can hardly be said, in light of those 7 or 8 examples, that the Supreme Court was saying to them, and of course you won't need to worry about whether the lex situs has destroyed your equitable interest if you do so. Plead your case, take your chances, see what comes of it. Now, as it happens, as you know in this case, there was a substantial issue. It was the second issue before the Court of Appeal, which in truth, as I said to the Court of Appeal, in our view, was the real issue, because we regarded this, the first issue, as clearly an issue which should be decided with the greatest respect in our favour as respondents. The real issue was the second issue. And this comes back to the question which Lord Stevens asked me yesterday. The real issue was whether the interests which Sickle retained in the shares under Saudi law were capable of being characterised as sufficient to constitute a continuation of the equitable interest in order to ground a knowing receipt claim. So the first question was, do you need to retain a proprietary interest? The second question was, well, if you did need to retain it, then does Saudi law give you sufficient meat to bite on in order to say that you've retained such an interest? And that's the point. That was actually the real point, so, to my perception of the case. That point was lost by the appellants before the Court of Appeal, and they haven't appealed it. So to come back to the question which my Lord Stevens actually asked me yesterday, and we got sidetracked into, forgive me, I'm sure I was responsible for it, we got sidetracked, about property going to a civil law jurisdiction. What's the consequence of that? The answer is, the consequence may be, and is in this case, that if the lex situs says that an unencumbered title is being taken, that registration on the share register is determinative, that's the end of the case. But it may be the case, turned out not to be, but despite the appellant's best efforts in this appeal, it may be the case that there are retained under the civil law jurisdiction rights of a sufficient proprietary-like character to enable you to characterize those rights as sufficient to actually ground a known receipt claim. And that was the second issue. And as I say, that's gone. But your lordships don't really need to concern yourself with that. The point is,
I asked that question because I was interested in what Mr. Justice Millett had said at page 1141.
Yes.
And in El Adju, because the second proposition was whether the money had been transferred to recipients in civil jurisdictions, whether that then defeated a tracing claim. And he rejected both submissions. He rejected that submission on the basis that foreign law hadn't been pleaded, but he then went on to analyze it in the alternative. And I was interested to know whether or not you considered that his alternative analysis, albeit obiter, was incorrect.
Yes. Well, I think the way we approach it, just to cut through this, is that the explanation of what he decided in El Adju, which he gave in Macmillan, is actually the explanation. What he said was that he was concerned there only to be describing the limits of the English law of tracing, discerning the English law of tracing. And he was saying, in regards to the English law of tracing, the fact that the property had remained either in the hands of or under the control of the fraudsters in the process of coming along its route to the third party meant that the fact that the fraudsters had as it were, laundered the monies through jurisdictions which were civil law jurisdictions were not going to stand, it was not going to stand in the way of the identification of the property, which was all that tracing was concerned with, as the property of the original beneficial owner, which had reached the hands of Dollar Holdings. So his explanation in Macmillan was that this was all about tracing, and what he said was that tracing operates by reference to the notional concepts of equitable charges. As I think that is actually what he said in El Adju. It operates by reference to notional concepts of equitable charges, but because it's merely concerned with the process of identification and not actually the imposition of a remedy, it's your only concern is literally to be able to say, subject to mixing and all that sort of those sorts of considerations, you'll be able to say that, well, actually, I can follow the property through to its recipient. And where the tracing exercise involves the fraudster or his confederates having transferred through civil jurisdictions, that is not going to prevent the court from saying it remains identifiably the property of the beneficiary. So the question is it identifiably the property of the beneficiary? That's the tracing question.
It seems quite hard, though. I mean, we don't have to decide it, but if the effect of the lex situs is to extinguish any property right, I don't see how you can still call it your property after that.
Right. Well, I think the answer to that is that that may suggest that El Ajou in this particular respect was wrongly decided, but it certainly doesn't suggest that it can't be the case. I mean, the point here, I think, if I may say so collectively, is that we may raise a collective eyebrow in relation to what was said in relation to tracing by Mr. Justice Millett in El Ajou. But the reason we are raising, if I may say so, an eyebrow is because we recognise the significance of the lex situs in extinguishing title. What Mr. Justice Millett said in Macmillan, where he faced exactly the same submission as my learned friend is putting to you, was, no, what I said in El Ajou has nothing to do with the question of whether you can make a proprietary and personal claim as against a third party. I was simply concerned with tracing. Whether you buy that or not.
Have a difficulty in understanding how it is, if you have property, it goes to a civil jurisdiction country, comes back again to a volunteer in this country. Why can't the volunteer just simply say, well, it's my property, I own it, there's no beneficial interest whatsoever?
I think, my Lord, as a matter of generality, if I may say so, I perfectly understand why you say that. And I would, and if necessary, we would endorse it. But we would say it's entirely consistent with the case that we're putting before you. But what Mr. Justice Millett said in Macmillan, if I can just turn it up, help me find it. His explanation of what he thought he was deciding was slightly different. Page 431, thank you. Page 431. And it's the discussion from 431 through to 432. And the coup de grace is actually between B and C.
But on 432?
On 432.
It really starts on the bottom 5 lines of 431, doesn't it?
Correct. I'm so sorry, I should have referred you to that. In the course of argument.
Where he by then got to was inconsistent with El Ajou.
Yes, precisely.
Tracing, not title.
Exactly. That was his approach. And look, you may not find it entirely convincing, yeah? But then the answer to that is, well, what he said in relation to tracing principles was not convincing. But the reason it's not convincing is because, with respect, you agree the significance of the lex situs. And the reason, if I may respectfully suggest, that, as I say, it was my collective eyebrow point, the reason that we're having this discussion is because we approach, when one has an inclination to approach these questions on the basis that the lex situs and extinction of title is actually determinative. And that's the reason why we're pausing at El Ajou, not because El Ajou is suggestive of the respondent being wrong in relation to knowing receipt in this case. Yeah? And the suggestion, which is my learned friend's suggestion in this case, that I mean, they actually say very ambitiously at paragraph 55 of their written case, their secondary argument in relation to Macmillan is, their primary argument is Macmillan's not a knowing receipt case. Yeah. But at paragraph 55 of their written case, they say, our secondary argument is that Macmillan was wrongly decided, see El Ajou. And you step back and you think to yourself, well, El Ajou was Mr. Justice Millett in, whenever it was, 1993 or so. 1993. Sorry, no, that's Macmillan. El Ajou, I think, El Ajou was 18 months before Macmillan. I do know that. El Ajou was 18 months before Macmillan. It was Mr. Justice Millett. Mr. Justice El Ajou was 12th of June 1992. Macmillan was December the 10th, 1993. Okay, 18 months. El Ajou was 18 months before Macmillan. It was actually cited to Mr. Justice Millett in Macmillan. Mr. Justice Millett in Macmillan rejected its relevance to the case before him. But furthermore, Macmillan didn't stop with Mr. Justice Millett. It went to the Court of Appeal. And how can it be contended that the decision of the Court of Appeal in Macmillan is wrong because of El Ajou? Remember, so what I'm focusing on is my learned friend's secondary case. His primary case, we acknowledge, is that Macmillan's not a case of knowing receipt. His secondary case is it's wrongly decided because it's inconsistent with El Ajou. We say that, with respect, can't stand. Now, that was a excursion away from where I was, but I'm very grateful for it, because it's, with a very great assistance from your lordships, it's enabled me to make some of what our key points in response to the claim against us, as regards one, the fallacies based on the in personam, not in rem jurisdiction, and what was actually being said in Lightning. Those two counter-examples, which we discussed, of, well, we can't claim the property, but we can claim its value, which is the claim here, and we can't claim the property, but we can, in personam, get a declaration that we have an equitable interest in it, and then get an order for its restoration. Sorry, not right. It's also enabled us to look at the 7 or 8 references in acres, which set up a clear barrier, and to discuss the relationship between El Ajou and Macmillan, my lord. So now, where we were in our discussion, I think, was that I'd taken you to what Lord Brown Wilkinson had said in relation to whether you held property on trust in circumstances where you've taken subject to someone's equitable interest. We've had what is a very rewarding discussion from my standpoint about the nature of the analysis in those cases, and we've seen that, subject to anything Lord Brown Wilkinson may have said later in Target and Redferns, the basic analysis is that you may or may not hold on trust, but if you're going to have the obligations of a trustee imposed upon you, you need something more than notice. You need something more than being a mere volunteer. You need knowledge. That is Montague. That is Westdeutscher. That is knowing receipt. And that was the second point that I was going to make. The second point is that in order additionally to impose on a third party the obligations of a trustee, obligations to account as if you're a trustee, something extra is required than property ownership.
So the second point is?
Is the point that in order additionally to impose on a third party the obligations of a trustee, something extra is required, something extra over and above the retention of an equitable interest. And echoing Montague, and as we've seen, Lord Brown Wilkinson in Westdeutscher, that something extra is knowledge on the part of the third party that he's holding trust property, which has been transferred in breach of trust. The third party is then liable to account as if he were a trustee, although we all know that he's not. Right. It's at that point, the point of obtaining knowledge that one's holding property continuing subject to the beneficiary's equitable interest, that those personal custodial and restorative obligations are recognised. And at that point, the third party becomes open to the full gamut of consequential remedies for failure to act in accordance with his duties. It's at that point, when you have the knowledge, that you become open to the full gamut of consequential remedies for failure to restore and failure in your custodial obligations, which are catalogued by Mitchell and Waterson in their article. Now, we'd respectfully suggest that what we have just described to you as a matter of principle is the orthodox position, and it has been for decades. It's not been changed by anything said in Williams, and much less by anything decided in that case. And the reality is that, with all due respect to the appellants, there is not a single case which, properly understood, is to a contrary effect. With the exception, as my Lord Briggs mentioned at the outset, of Hakan Raja, based on concession, and in any event, no longer capable of standing as reflective of Sir Lancelot Henderson's views in light of what he has now actually held in the Court of Appeal in Davis and Ford, and that's the case at 900, and your lordships saw our reference to it, but it's that the passage is paragraphs 74 to 82 at pages 925 to 927. And we deal with this at paragraphs 147.4 and 154 of our case, pages 157 and 159. But if at 900 is the decision in Davis and Ford, and at 74 to 82, if we just turn it up for a moment.
So what page?
925 to 927, please.
925.
Yes, and 927 is the coup de grace. So at 925 to 927...
Well, he's following what was decided by the Court of Appeal in this case.
a little bit more than that, my Lord. Paragraph 82. I hope that the short passages which I've quoted from Byers are enough to show why I'm unable to accept this submission, which is, in my view, contrary to established principles dating back at least to the Elajou case in 1994. That is the Court of Appeal. And as your lordships will have seen, and I know Lady Justice Asplin was in this case previously also, Lady Justice Asplin made the point in agreeing at paragraph 170, which is at 952, that it wasn't simply, so far as she was concerned, a matter of following Byers. She says at paragraph 170 at 952, as Sir Lancelot points out at 82, the relevant principles in this regard date back at least to Elajou, and Lady Justice McClure agrees at 172. I mean, there really is not a case. And when my learned friend was going...
So she hadn't changed her mind in the previous 6 months or so?
No, she was no. Well, she'd heard lengthy submissions.
Yes.
So the reality is there's not a single case which the properly understood is to the contrary effect. And whereas every indication, and we would say every decision that's come anywhere near addressing the point, proceeds on the basis that having a continuing equitable interest is a feature of, indeed a necessary condition, of bringing a knowing receipt claim. And in recent times, the importance of the third party not having taken free of the beneficiary's equitable interest has been referred to right through, as we say, right through Lord Mance's judgment in Acres. It was clearly expressed by Mr. Justice Newgee in Courtwood, reflecting, we would respectfully say, a general understanding, not some personal theory. And it has recently been explicitly confirmed by the Court of Appeal in Davis, affirming what the Court of Appeal had previously said in the previous case. And that's just the recent position. As we've seen, this feature of knowing receipt claims was expressly recognised by Lord Nichols in 1998 in his landmark article. And I'm going to show you other examples in a moment. It's plainly, we would respectfully suggest, the basis upon which Sir Robert McGarry was approaching the question in Montague. And we refer you to the quotations at paragraph 86.2 of the Respondent's case. That's 134 to 135. We might just turn that up, 134 to 135. Paragraph 86.2.
In your written case?
Yes. I'm just taking the Montague references from there, but I'm happy to take them from the...
For my part, I'd rather have it, as it were, from the horse's mouth.
Well, in that case, could we go to 506 and 512?
Right. And this is the case of a volunteer.
Yes.
Yeah.
Yes. But as...
So the moment you know it's a case about a volunteer, the subsistence of the beneficial interest is assumed.
Exactly.
Yeah.
Indeed, and it's implicit in the discussion. Because the whole point about what's being said in Montague is that you're dealing with a case where you haven't got a bona fide purchaser. Because if you had a bona fide purchaser, you wouldn't be having the discussion. And this is a very important point about Montague. None of what Sir Robert McGarry was saying in Montague would have required articulation if he'd been dealing with a bona fide purchaser. Because we all know that a bona fide purchase actually destroys knowing receipt claims. It does. So the whole discussion in Montague is proceeding on the basis that you're dealing with someone who has taken subject to an equitable interest. And the whole point that's been made in Montague is, in that case, in order to be a knowing recipient, you need something more. And again, it's the point which I was introducing in answering my Lord Stevens last night. Montague is clearly proceeding on the basis that you need something more, because the matrix within which the discussion is occurring presumes that you must have taken subject to the equitable interest. If you had not, then you wouldn't be having a discussion about knowing receipt at all. And in that context, we go. The first reference in our case is actually at page 506. It's not a reference that my own friend took you to. It's between letters E and F. The question, says Sir Robert, is not merely whether a person is to take a property subject to an equity, but whether the full burden of trusteeship is to be imposed on him by construction of equity. Between E and F.
Oh, thank you, yeah. Yeah, got it.
Yeah? So, as I say, we're having this discussion in the context of it being a given that you have taken property subject to an equity. Otherwise, we couldn't have the discussion. And so the question is not merely whether a person is to take a property subject to an equity, but whether the full burden of trusteeship is to be imposed on him by construction of equity. And the other horse's mouth source is at page 512. And this is, it's actually at E. My learned friend took you to the passage between B and D, and he rounded off with the appropriate reference to man being understood as a person. But what he didn't take you to was the following sentence.
Yeah.
I would only add that there's more to be made a trustee than merely taking property subject to an equity. And that's the same point. It's a very short point, and that's why I said we'd just look at it in our written case. But it's a very short point. But it's important to understand that Montague it's a straight down the line decision relating to a case where you have taken property subject to an equitable interest. So that's Montague. We saw yesterday the quotation from Ajib at pages 688 to 689, which had been set out verbatim at paragraph 56 of the Respondent's case, 127. But please, by all means, we can look again at 688 to 689. It's there, as we noted, that Mr. Justice Millett distinguished at the bottom of 688 and then tipping over into 689. He distinguished between knowing receipt and knowing or dishonest assistance, and he said the basis of liability in the two types of cases is quite different. There's no reason why the degree of knowledge should be the same, and good reason why it should not. Tracing claims, i.e. proprietary claims, and cases of knowing receipt are both concerned with rights of priority in relation to property taken by a legal owner for his own benefit.
Sorry, where are you?
68, bottom of 688, tipping over to 689, I believe.
Yeah.
Yep. It's the quote that I gave you last
yesterday.
time. Yeah. And then there's Boscawen and Barja, which we'll come back to if we have time, but you've seen the quotes from that. And then we've got Macmillan, we've got Lightning, and we've got Akers, Akers being the most authoritative, obviously. And we've looked at that, but there's a few more things I need to say in relation to it. So that's my introduction as to why, in principle, we're right. But there are, as I say, some points I need to tick off from yesterday, and at least one of them I have ticked off, because one of them was going to be, well, perhaps two of them. Two of them I've ticked off. One of them was going to be the in personam, the nature of the claim in Lightning, the in personam, not in rem claim, the Ewing or Ewing claim. It's that claim that is being said to be barred by the lex situs in Lightning, notwithstanding what my learned friend says. And we've debated the incoherences of the consequences of not recognising that in this case. And the other point that I was going to go back to was the company director point. And I've, subject to anything that you may say to me, I think I've said everything that I can in relation to that. But as the other points that I wanted to make to you were these. And the first is the one I've already trailed. Yesterday, the appellants placed emphasis on the remedy in knowing receipt being one of account. And they presented the remedy to you as if it were limited to a money claim based on falsifying or surcharging the third party in respect of his dealings with property. That notwithstanding, they have suggested that compensation for loss is not a remedy in knowing receipt. And the fact that a compensation for loss claim formed part of the personal claim in equity in Macmillan, they say evidences that what was being talked about in Macmillan was something other than knowing receipt.
Yeah.
Okay. And this is, with the greatest of respect, simply wrong. And I would ask you, please, to read the Mitchell and Watterson article. It is, as I've said more than once already, exceptional. It's an exception. It's the remedies for name receipt. That article is, as you know, at 2396 and following. It is the landmark treatment of the subject. We've had a debate as to whether the odd reference by them as to constructive trusteeship is of significance or not. It does not infect the comprehensive cataloguing in that article of the remedies that are available.
And whereabouts in the article do they have compensation for loss?
Okay. Well, the discussion, I'll get the article up. I should tell you, my Lord, as a quick way into this,
yeah.
Goff and Jones, which of course they write, has got a short treatment of this at well, perhaps we can go to Goff and Jones first, because it actually uses the words compensation for loss.
Thank you.
Thank you. So yes, the extract is, begins at 2332. The description of the remedies is at 2334 to 2335, and it's paragraphs 8199 and 8200. And you'll find a reference to compensation for losses at the end of 8200 on page 2335. But this is, if you like, almost like an abstract. This is these two paragraphs of Goff and Jones, 8199 and 200, are a précis of what is said at much greater length and with much greater authority, including citation of authority, in Mitchell and Watterson. And so far as regards Mitchell and Watterson itself,
yes.
So it's the last sentence in 8200.
well, yes, indeed, that is the compensation for losses sentence. But if you look at the
So you either go for performance of the, let us call it constructive trust, or you go for a breach of that trust.
exactly.
Yes.
Precisely, the as-if trust. The obligation to account is to make, as you'll see from the article, because it's summarised in one line.
It doesn't have any footnote against that sentence.
No, but we've got. If your lordship will just go with the flow on this and look at the Mitchell and Watterson article, and I didn't have a reference to immediately to hand. I'm not sure that I've marked it up.
No.
But the fact is that if you go through the article, the relevant discussion starts at 2401. And the duty to account is explained at length there. In terms, if you go to 2403, that the accounting process this is the first full paragraph on 2403. The accounting process is the conceptual mechanism through which beneficiaries can bring two different types of compensation claim against trustees, which will be termed, and this is very often used in practice.
This is 2403.
Yes,
2403, the first full paragraph.
Yes.
You see, the accounting process is the conceptual mechanism through which beneficiaries can bring two different types of compensation claim against trustees, which will be termed, as I was saying, this is in quite general usage, if I may say, substitutive performance claims and reparation claims. Substitutive performance claims are claims for a money payment as a substitute for performance of the trustee's primary obligation to account for and deliver trust property in species. Claims of this sort are apposite when trust property has been lost or misapplied in an unauthorised transaction, and the amount claimed is the objective value which the trustees should have been able to produce when called upon to do so. Reparation claims are claims for a money payment to make good the damage caused by a breach of trust, and the amount claimed is measured by reference to the actual loss sustained by the beneficiaries.
Yes.
Then each of them.
So he looks at the substantive performance claims in section 2, and then at section 3 at page 2407, he makes essentially the same point as was made by Goff and Jones, that these are claims where the trustees have not performed their duty. They are breach of duty claims.
Yes, indeed. And indeed, and that's what I was going to say to your lordship, that general introduction is then elaborated over the following pages as to explain the content. And the general message is, and I don't know whether there's a footnote relating to compensation for lost claims, there may be, there may not be, but the message is straightforward. It is, you have the full spectrum of remedies which would be available against an express trustee. That's what is meant by saying you shall be liable to account as if you were, for what it's worth, a constructive trustee. You shall be liable to account as if you were a trustee. The point, and it's the Mitchell and Watterson point, is that you've got the full spectrum of remedies. And compensation for loss is certainly a remedy which is available against express trustees. And then the discussion can be picked up again. I know your lordships will...
Actually, reading this text, he's talking about these remedies in relation to breach of trust generally, and you have to keep reminding yourself that the whole subject heading is liability for knowing receipt.
Yes.
Yeah.
Yes, because indeed, because they're saying these are the consequences. Yes.
Yeah.
And then, but then distinctively and particularly from 2412 onwards, you've got the discussion of the restorative duty, the core restorative duty, as it was identified as being so in Arthur, and then further, and the remedial implications of that, and then further the other duties at 2419, of which one sees at 2419, as it were, a rendering of the custodial duty. Duty to preserve and or invest the property. A duty of restoration is not inconsistent with the duty to take care of the property while it's in the known recipient's custody, which is what my Lord Byers and I were talking about earlier. Obviously, it's only going to be in an extreme case that start the sentence again. It's going to require particular facts for you to be able to deduce that the third party has a particular investment obligation in relation to the property. Clearly, if the circumstances surrounding the property suggest that it should be applied in a particular way, if it was invested in a particular way, then safe custody involves preserving the benefits of that investment. There may, it's suggested in this article, as it is suggested in Goff and Jones, be very particular circumstances where a more active investment obligation arises. We don't need to concern ourselves in relation to that.
And that creates all kinds of difficulties because the express trust will create all those powers in terms. And big question whether they transfer to the knowing recipient.
Well, and it seems rather, well, exactly. And that deep water,
yes.
but that made me fact dependent on what the knowing recipient knew.
Yeah, okay.
And then you begin to get into the territory of, did he assume a trusteeship in a sense, in that he knew precisely what should be done with this property when he received it? But these are quite different questions. They're really interesting, but they don't arise.
This is really all a long run up to Macmillan, isn't it? And understanding why Mr. Justice Millett keeps referring to or pay compensation for loss.
Yes, and other references to remedies which are available in knowing receipt. But I'm going to show you something in a moment which tells you unambiguously that knowing receipt must have been the claim in Macmillan. Okay. So that's the duty to account. That it's perfectly true to say that notions of falsifying or surcharging accounts can be invoked in the traditional language of equity. But the fact is that the spectrum of liability which applies in relation to a knowing recipient is not restricted to making limited money claims. It involves the custodial, restorative, and restorative duties and everything that flows out of that, the full gamut of potential claims. Now, the second point that I was going to make was this. My learned friend addressed Boscawen. We have addressed Boscawen in our written case. Whilst it's true that what Lord Justice Millett said in Boscawen, and I'm saying this as a lead-in to a punchline, whilst it's true that what Lord Justice Millett said in Boscawen was somewhat compressed, and it's not helped by the fact that he's dealing with dishonest assistance in the same breath when he's talking about tracing, it's clear from that case that when he was addressing knowing receipt, he was saying that retention by the beneficiary of a beneficial interest in the property was essential to such a claim. I'll come back to Boscawen if necessary in a moment. But he was saying that, and it's no surprise that he was saying that retention by a beneficiary of a beneficiary interest in the property was essential to a knowing receipt claim. It's no surprise he was saying that, given what he'd said in Macmillan a couple of years earlier about the essential nature of a proprietary base in third-party cases, that is, cases where there is no privity between the parties. And I'll come back to this. But I wanted to draw your attention to this. It's interesting to note that 2 days prior to hearing Boscawen, Lord Justice Millett gave a lecture at King's College London, the text of which is at 2372, and it's entitled 2372. It's also made it to Trust Law International, but it's better. The copy is clearer that we've given you. 2372. The lecture is entitled Equity, the Road Ahead, and it contains characteristically trenchant analyses expressed in characteristically trenchant language. But I wanted to draw your attention to pages 2384 to 2385, if I may, please. 2384 to 2385. And we pick it up as a read-in at the middle of the page of 2384.
What year was this?
This was 1995. So this was the 14th of March 1995. That appears on 2372. And I believe that the hearing in Boscawen began on the 16th of March. So it might have made interesting reading for the parties if they'd seen a copy or attended the lecture. So 2384, we pick up the text that next we must resolve the controversial question. And then the next paragraph is talking about accessory liability, talking about dishonest assistance. And then knowing receipt. In the case of the recipient who sets up his own adverse title, the question is still unsettled. This is as to the knowledge question. Okay? The authorities are all over the place, yet the problem is capable of solution if we apply the basic principles of equity. If the defendant still has the money, the dispute is about priorities. The plaintiff is still the owner in the eyes of equity. If he makes a proprietary claim, why should he not recover his property from the person to whom legal title has passed? We should ask ourselves, what defence is there? And the answer is bona fide purchase of the legal estate without notice, actual or constructive. Equity has never allowed the beneficial owner's interest to be defeated by an honest but foolish purchaser of the legal estate without notice who acted unreasonably by failing to make proper inquiries. The punchline. Precisely the same, however, applies to the defendant who received the plaintiff's money but has since parted with it and, when challenged, claimed that he was entitled to do so. He is still setting up his own former title to the money. The question is still one of priorities. The defendant can only succeed if he has a bona fide purchaser of the legal estate if he was a bona fide purchaser of the legal estate without notice, or can rely on change of position. So the need in a knowing receipt case to rely on title is clearly reiterated by Lord Justice Millett a couple of days before he heard Boscawen, and it endorses what he actually, the clear interpretation of what he said in Boscawen. But as a further point I'd like to make by reference to this article, because this does...
I mean, that's not a correct statement of the law, the last sentence, is it?
No. It isn't, and we know that as regard that's not. But the general point as to what he meant and understood by the law in relation to whether, as a known recipient, you needed to be subject to a title claim is a clear endorsement of what he'd been saying elsewhere. But there's another very interesting passage in this article.
And it looks as if that's in the context of a theory that you might wish to move to strict liability.
Mm.
Well, yes, and you may also say that it's in the context of perhaps saying that knowledge shouldn't be the test, that notice should be the test. Yeah, maybe. But the basic point is, whatever the test, it's a property claim that he's endorsing, and it's the same as the only reason I've referred to this is actually in order to make clear that there's no ambiguity, there's no confusion about what he was saying in Boscawen in relation to this a few days later. But I've got another motive for opening this article, and it's provided at pages 238 to 2380 and 2381. And it's on 2380, again, it's road ahead stuff, this, but if you pick it up at there is one important branch of the law, and then read through to the end of the paragraph on 2381. And my point is the point made at the top of 2381. When it comes to claims in equity, there are proprietary claims, and then there are knowing receipt claims, and then there are dishonest assistance claims. In relation to personal claims, there's knowing receipt and dishonest assistance, but there's no third game in town. So when you see under a heading of restitution in Macmillan, references to claims in equity for restitution, for restoration of property in the hands of a third party, personal claims in equity for restoration, personal claims for compensation for loss. There is no third game in town. It is knowing receipt. And the same point is made actually by Mr. Justice Millett in El Ajou at 1143. If we might turn that up.
Sorry, not sure I follow this point. What is this other game in town?
Well, I'm saying, so sorry. Well, the suggestion is that Macmillan was a case where it was referring to personal equitable claims, personal restitutionary claims, yeah, which plainly were claims which were equitable claims, yeah, that it was referring to something other than knowing receipt. And I'm saying to your lordships that what this point is making clear, as the point which I'm now about to draw your attention makes clear, that knowing receipt is actually the remedy. There isn't another equitable remedy out there. You may put it in under a restitutionary umbrella because that was the taxonomy of the time. But the fact is, knowing receipt is the claim. And that very point is made by Mr. Justice Millett in El Ajou at 1143. You could go to 1143, it's between G and H.
Whereabouts?
It's literally between G and H. In my judgment, this is the tracing through civil jurisdictions section, where but even if the argument were open to DLH, I would reject it. This is we know the argument. In my judgment, it's misconceived. And here's the points. For technical reasons, the plaintiff's claim is brought in equity, where it is of a kind generally described as a case of knowing receipt. This is the counterpart in equity of the common law action for money hadn't received. Both can be classified as receipt-based restitutionary claims. So the claim is known as knowing receipt. The fact that you refer to a claim as a receipt-based restitutionary claim, but the fact that you classify it as a receipt-based restitutionary claim, underline classified, if you will, the fact that you may classify it in the taxonomy of the day as a receipt-based restitutionary claim doesn't get away from the fact that what it actually is, and has always been up to this time, is something which is generally described as a case of knowing receipt. And the same point was actually made by Lord Millett in an essay. This is my last reference to Lord Millett, extrajudicially. The same point was made by Lord Millett in his 2005 essay, which is at 2393 to 2394. Please, 2393 to 2394.
Just if you could just unpack, can be classified as a receipt-based restitutionary claim, begs the question as to whether it's receipt of a beneficial interest or not. Well, I mean, just that one sentence, does it provide the answer to this case or not?
Well, I'm not suggesting that sentence is providing an answer to this particular question. The reason I'm referring to the sentence is for a different purpose. I'm referring to the sentence in order to make good the point that the claim is knowing receipt. The fact that it may be classified as a restitutionary claim and was so attemptedly classified in Macmillan doesn't stop it actually being a knowing receipt claim.
Yes, I mean, you're citing this as a part of a build-up to looking at Macmillan.
Exactly.
Yes.
It's the long run-up.
Yeah.
It's the long run-up.
Very
you can see exactly where I'm going.
Yeah, well, we're looking forward to the ball being delivered, I think.
2394, I think, was
2393 to 2394.
And this is
an article by, and the full article should be there, but it's not, which apologies. But it's an article by, no, it's not, sorry.
Sorry, I've turned up the wrong page. Yes, it's a chapter in a book.
It's a chapter in Edelman's book, I think.
Yes, it is. No, that's absolutely right. No, forgive me, I turned to the wrong page in the bundle. Yes. And so it's this, it's the passage at the end, at the bottom of 2393, tipping over to the top of 2394. Really, one needs to begin with the preceding sentence. A proprietary claim is confined to the asset remaining in the defendant's claims, in the defendant's hands. But the claimant is not without a remedy in these circumstances. He may have a personal remedy, for property generates personal as well as proprietary claims. There are two kinds of personal restitutionary claim: the purely personal claim, which is brought to reverse unjust enrichment, and the property-based personal claim, which is brought to recover the value of the claimant's property. A property-based personal claim to restitution is available whether the defendant has parted with the property or not. At law, the claimant had an action for money hadn't received, which lay not only where the defendant was personally indebted to him, but also where he had the claimant's money in his possession. In equity, he has a claim for knowing receipt. So it's the same point again. There is no third game in town. There's only, and if you're bringing a claim otherwise than a personal claim in equity, otherwise than based on dishonesty, based on receipt, it is a claim in knowing receipt. And you can call it restitutionary for whatever your purpose is, because you're trying to trailblaze into a new categorization of law, because it suits your purposes to classify it as restitutionary, because you're trying to persuade a court to apply the English bona fide purchaser rule rather than the New York bona fide purchaser rule. You may have any number of motives for trying to classify it as restitutionary. Yeah?
I think the other game in town is an independent claim to unjust enrichment, and there is that slight difficulty that he seems to be including that alongside his personal claim. So I actually myself, I'm not sure you're going to get too much from all this. The reference to a restitutionary claim in Macmillan, I think, is open to interpretation. You want to say all he meant was knowing receipt. Well, I think there's enough confusion about what, with respect, Lord Millett was saying in these articles and in some of his other judgments, that I think we're asking rather a lot to make it absolutely definitive that when he used the phrase restitution, personal restitution claim, he must have been referring to knowing receipt.
Well, my lord, you have our submission on this, and our submission is personal equitable claims, it's only known receipt. Restitution was being used for terminological reasons, whatever your objective. Yeah? And whatever else you say about Macmillan, the general proposition that is put forward between pages 988 and 990 of the report, the proposition that you distinguish between cases where there is a privity between the parties and cases where there's no privity, that general proposition is perfectly general. And there is no suggestion that it would not apply to knowing receipt. Indeed, there is a suggestion that it does apply to knowing receipt, but may have been lost sight of. Yeah? But there is no reason to treat Macmillan as anything other than a knowing receipt case in our respectful submission, because that's what the law was in 1993, 1995. That's what textbooks were dealing with in relation to personal claims to account and for compensation and restoration. And frankly, it's what the law is today. Today, the law is that you bring a knowing receipt claim. Witness the fact that that's what the appellants did in this case. That's the law. That's, you go to Lewin on trusts. Of course there's a discussion as to the basis of knowing receipt, but you've got 30, 40, 50, 60 pages on ancillary liability, and knowing receipt is one of the two games in town. And so the idea, as we've said in our written case, that the exceptionally experienced counsel in Macmillan, bringing claims where hundreds of millions of dollars were at stake, thought to themselves, I know, it's a completely undeveloped area of the law. We won't make a claim in knowing receipt. What we'll do is we'll have a shot at a restitutionary claim and take our chances. The idea that that's what they were doing, I think, is beggars belief. And I mean, it would have been an exceptional exercise of incompetence, frankly, to have done that. And it's unbelievable. It's barely believable in the 1990s that someone would not have pleaded knowing receipt in such a case. And my learned friend says, as a final point, if I may make, we're at 1 o'clock. I'll stop now.
You wish to return after the run-up to Macmillan at 2 o'clock?
Yes.
Can I just also say that I hope you won't run out of time to look at this point raised in your case, paragraphs 92 following, about where the property has passed through the hands of a bona fide purchaser who subsequently acquires knowledge, or the other example you gave where a second recipient is a bona fide purchaser. Because I would just like to ask about the Independent Trustee Services and GP Noble case, where there is a reference to possible exceptions to that in relation to actual or constructive trustees. I'd be interested to know what your submission on that would be. And I've also not forgotten that you were going to come back to the criterion case, potentially, unless you want to put your submissions in writing.
Well, I think we're probably going to need to put submissions in writing because I don't have a copy of it with me. But as I say, we are well aware of the point, but I don't think I could do it justice now. So far as regards Noble, we'll go in search of that particular reference and hope to satisfy you after lunch.
Of course,